Hi, I'm Shan Wu with a Under Color of Law hot take on some of the misconceptions about what's happening to the Jack Smith Special Counsel federal cases. So recall we have two of them, right? We've got the classified documents case, that's Mar-a-Lago in Florida, and we've got the January 6th uprising interference case here in DC. So they're both still alive. The Florida one has been dismissed by Judge Eileen Cannon. They're the Trump-appointed judge who might even be on the short list to be the new Trump AG. And it's being appealed, though. Her dismissal on completely bogus reasons that Jack Smith was unconstitutionally appointed, that's actually being appealed. So it's still alive, even though the trial court dismissed it. The second case in D.C. with Judge Tanya Chutkan, that's very much alive. There were various deadlines. But Jack Smith asked the judge to put those off until he can give her a proposed schedule because he said that, well, from reporting, he indicated he was in discussions with DOJ leadership about how to resolve the cases. Then he made a particular motion with the trial court asking to put things off formally, and the court basically immediately granted that. So there's some misconceptions about what's going on here. Certainly on the right, the MAGA folks are trying to add to that misconception and spinning it. And so let's take a listen to a couple of misconceptions going on. First, let's play this clip of Professor Jonathan Turley talking about what he feels is the state of the cases. We'll take a listen.
The answer to that we sort of know with regard to Special Counsel Jack Smith. He became a lame duck prosecutor at about 2:30 a.m. last Wednesday.
So what's really striking about Turley here is he uses this term lame duck. He refers to Jack Smith being a lame duck prosecutor as of 2:30 a.m. I guess he means, when the election results came in. It's actually very revealing on Turley's part. It tells you what his real motivation or what his real perspective is. Lame duck, as many of you know, that's a term for when the president or Congress, they're sitting at the end of their term, meaning they're not coming back. The president's a lame duck because he's not coming back to the presidency. That's what that term means. That's a political term. It's not a term about prosecutions. There's no such thing as a lame duck prosecution because prosecutors aren't voted in and voted out based on their cases. Some of them are voted in or voted out as opposed to appointed, but that's not how the cases work. There's not like a vote by voters as to whether to bring a case or whether to keep it or not. So that's a political term that Turley is using, which as a law professor is interesting. He uses that term for prosecution. Now, one more clip here, Representative Luna talking here. Take a listen.
We knew from the get-go that Jack Smith was operating under the purview of the White House and at the direction of President Biden to go after his political opponent. But what I will tell you, Maria, is that Jack Smith violated the Constitution. There was never congressional oversight on anything that he was doing.
So she's saying that Jack Smith has performed his duties in a unconstitutional way. Now, we know they feel that his appointment's unconstitutional. Judge Cannon agreed with it. But what is her reason for saying it's unconstitutional? She says that Jack Smith, who's acting as a DOJ prosecutor, he's a special counsel, but still part of DOJ, that he is acting unconstitutionally because he had been given no oversight by Congress. And what she means by oversight are committees like Jim Jordan's I went to testify in front of that's trying to look at these different prosecutions. Okay, now DOJ is subject to oversight. Congress has a right and ability to conduct oversight hearings about various federal agencies, but they typically are not able to conduct oversight over an investigation or a case as it's actually proceeding. They can try, but the Justice Department does not report out on, we put so-and-so in the grand jury today, Congress, and we're thinking about this particular charge. Obviously, they're not going to do that because that's going to ruin the integrity of any investigation. It doesn't matter whether it's a Republican or Democratic Attorney General. DOJ is subject to oversight, but they're not subject to reporting to Congress as they go along, like asking for permission for each step in their investigation. So that's just the spin, or perhaps Representative Luna actually doesn't understand that. Possible. Now, the real reason that Smith is winding down is because of the fact that DOJ has a policy that you cannot prosecute a sitting president. And that's based on, there's a division within DOJ called the Office of Legal Counsel, and they write opinions. They're very smart people and give the Attorney General kind of his counsel or her counsel as to almost acting like an inside general counsel for the Attorney General. Now, they have a memo that says DOJ doesn't prosecute sitting presidents, and that really originated during the Nixon era and then during President Clinton's era, when those two sets of lawyers, separated by quite a few years, all argued, hey, you can't bring a criminal prosecution against the president when they're sitting because that's going to really screw things up. How are they going to run the country when they're busy defending themselves against criminal prosecutions? Notice, well, you can't notice it because you're not seeing it, but all those arguments were not really based on this is a politically motivated prosecution. Certainly, Nixon was a big believer his enemies were out to get him. Clinton felt the same way. But the real reason was this idea that it would be too much interference for the president trying to run the country. Now, I don't agree with that. Other countries do prosecute their leaders and sitting presidents. Take a look at some examples of that. And some scholars question whether the OLC type of opinions or memos really have any binding precedent. There's a great law review article by Professor Kimberly Wheel. You can take a look at that. And it shouldn't be legally binding. I mean, certainly it can be persuasive and a guideline that the agency, DOJ, wants to follow. But over the years, it has become far too powerful to use that almost like a judicial policy. The Justice Department is the nation's lawyer. I remember that phrase, and that attracted me to want to go work there. But they're not the nation's judge. They're not issuing opinions for the nation. That's just guidance within the department. So I really think that needs to be revisited somewhat, particularly because of the abuses that we've seen during the Trump administration. So what are Smith's real options? I laid them out in an MSNBC opinion piece I did, so please take a look at that link for a deeper dive. It's no paywall. You can take a look at it. He's really got two options: dismiss the cases or pause them. The pause is meaningless and runs some risk of, once the Trump AG comes in, of the work and information really disappearing. I mean, NBC reporter Ken Delanian suggested that, as reported in Newsweek, that there's some danger of maybe they just bury it. We'd never see what happened to the findings. Professor Larry Tribe and others have also called for some immediate protection for the historical value and transparency, just to make sure that they're out there, just to release the documents right now and the findings. I don't think that dismissal is a good idea. Norm Eisen, my friend and esteemed colleague, really feels you shouldn't dismiss. Just keep going and force the Trump DOJ to come in and say, no, we're pulling the plug on it. I agree with that. I don't think you should do the other guy's work for them, the other side's work for them. But a little bit unclear how a dismissal would work with what I think is actually the best option, which is for the special counsel to write a report. So I think that what they should use the remaining time in the Biden administration to do is to write a report, and then they tell Garland to release it, which is within his discretion whether to release it or not. But he released Robert Hur's hatchet job on Biden, and Garland says he's going to take the advice of the special counsels and release it if that's what they want to do. They should lay everything out there because it's not going to affect the case. The cases are going to be dead when Trump comes in. It should, ideally, with the classified documents case, if there's any evidence about who that Trump may have shared the documents with, that'd be really helpful. A little bit of a legal conundrum here with grand jury testimony requires the court to allow that. So they should definitely litigate that. They should ask permission to release the grand jury testimony. Trump's folks may try and interfere with that, run it up to the Supreme Court. Supreme Court will probably help him out on that point. That may get gummed up. But there's lots of other things to release. The FBI interviews called 302s, They may fight about whether that gets transformed into grand jury material. My point, no, they originally weren't grand jury material. Putting them in the grand jury doesn't automatically transform them. You can keep the grand jury stuff out. Then you write a full report with all those exhibits, and you recommend prosecution. So I was saying there's a little bit of a conundrum with whether the case is still alive or not. If the case is still alive, then you have to be aware of the fact that theoretically people might object to this because DOJ usually doesn't issue a full report like that if they might still prosecute the case. Again, practically, there's no effect here. There's no danger here. They're never going to be able to prosecute these cases. They're dead because Trump's going to get rid of them. So it seems to me you could do both. But some of those discussions are probably happening are all about what should we do? Should we dismiss it and then do the report? Could we do a report if they're not technically dismissed? There's also a real in-the-weeds question of could it be dismissed with prejudice, meaning it could never be brought back? I don't think that the trial court judges are able to dismiss these with prejudice, but it doesn't really matter because they are dismissed with prejudice. They're going to be over. What is not over is our need and the ability of Special Counsel Smith and Merrick Garland and the Biden administration to give us as much full transparency as we can possibly get. That we need. So that's it for now. Thanks for listening. Thanks for watching. And again, great to have your comments. Let's talk to each other. Let's bring in a lot of sunlight on what's coming.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.